Case is now being live streamed.
Okay, thank you. Good morning. Welcome to the single justice session of the Appeals Court. I'm Justice Shin. We're here today on one case, Stonier versus WAC Consulting, number 20J17. We're going to set the timer, so each side will have 15 minutes. You don't have to use all of it. No rebuttal. Counsel should know that I have read the motion to dismiss and the opposition that was filed in the trial court, and I'm familiar with the issues. Okay, so with that, we'll begin with counsel for the plaintiff. Is it DRC or Darcy?
Darcy.
Darcy, okay. The floor is yours.
Thank you, Your Honor, and good morning to everybody. Thank you for having us today. As you said, my name is Alexis Darcy, and I represent the plaintiff, Jamie Stonier. I'll go over the facts briefly, cognizant of the fact that you've read the pleadings as you've indicated, Your Honor. Ms. Stonier was employed by WAC from 2009 through 2014, and then again from 2016 through 2017. During that last year, it became apparent to her that she would not be paid commissions as they were due to her under the employment agreement. In addition, at the time she separated, she was unpaid for a full month of work. So we brought suit in the Superior Court alleging violations of the Wage Act, seeking damages, including attorney's fees. My brother, on behalf of WAC, moved to dismiss our case, arguing that we had failed to establish the jurisdictional amount of $25,000. Before Judge Barry Smith in the trial court, it was found that we had alleged $16,686 in actual damages, and that if we were to settle or prevail at trial, we would be entitled to at least $8,314 in attorney's fees and possibly more. So those facts are not in dispute. What is in dispute here is a legal issue only. So, we will be asking for de novo review of this one legal issue, which is whether the common law or the general rule applies in Massachusetts state courts. And the common law rule and the federal rule, as I've discovered it to be widespread in the cases, is that attorney's fees do not count towards the jurisdictional threshold amount unless they are provided for by the contract at issue in the litigation, or if they are provided for in a fee shifting statute.
So let me just clarify one thing. So you agree that the only issue before me is whether the attorney's fees should be included in the jurisdictional amount, because I did notice in your opposition you raised a second issue that then did not appear in the judge's findings regarding the tort damages. Is that no longer in dispute?
Right. Well, that's an interesting issue to me. It's not at issue here in this appeal.
Okay. Before I forget, in the materials that I have, I don't have a copy of the complaint. When this hearing is over, could you please file that?
Oh, sure, with the appeals court, absolutely.
Yeah, thank you. Okay, please go ahead.
So as I was saying, the common law or the federal rule is that attorney's fees don't apply to the calculus unless A or B. We are in the B situation where we have a fee shifting statute. There are only two cases in Massachusetts that I've found that address this issue. The first one is actually an appellate decision. It's an unpublished decision called DeJankis v. Old Time Sports. And that is a landlord-tenant dispute. The landlord prevailed in that case and was awarded damages, including attorney's fees. On appeal, the tenant argued that the Superior Court never had jurisdiction in the first place because the complaint did not allege more than $25,000 of damages. And the appeals court said, well, your argument is untimely, but even if it were timely, we would reject it because the contract at issue had an attorney's fees provision, and therefore we are going to include that attorney's fees provision and deem that the damages were greater than $25,000.
Now, in that case, is it, can Can you tell whether the attorney's fees were already incurred or if the court was talking about reasonably anticipated fees?
They do say that it's prospective. So
Okay.
that to me sounds like reasonably anticipated. And you'd have to make this determination prospectively in every case that comes before a judge. So you wouldn't have the benefit of knowing at the outset of a case what the attorney's fees are going to be.
Right, but there is a split, at least in the federal circuit, regarding this issue, that at least one circuit court that I found has held that the amount in controversy, at least for federal purposes, is the amount of fees that have been incurred as of the filing, either the filing of the suit or when the case was removed to federal court. That's why I asked the question about whether it's evident in that case, whether, and it is unpublished, so.
Right. I did sort of stumble across that a little bit, but by and large, the cases, to me, the overwhelming majority of cases are anticipating what's going to happen. So there's the Velez case, the Spielman case. These are First Circuit cases. There's the Houston case. My brother and I pronounce it differently, but I pronounce it Houston. And at the end of my time, I was going to ask for a chance to submit a brief so that I can, a short brief, just so that I can give you these citations that I'm relying on. But by and large, I think that this is a prospective question because most people are not going to be incurring that much in attorney's fees prior to the case. But if that's
how does one make that prospective determination?
Good question. So in the Houston case, the judge asked that very question: how am I going to determine this? And what he did was he looked at 3 cases and he compared the ratio between the actual awards and the attorney's fees. So he had 3 cases and he said, okay, I'm going to average these 3 cases. So I'm going to he actually took the smallest amount, I believe, and said, these are the 3 cases that I see. I'm going to take the smallest amount and apply it here. I agree that that's a difficult question that has to be answered. But I'm also cognizant of my time, Your Honor. So, but I want to address your questions, but should I go on? Or?
Please.
Okay. So the Polian decision, that was a Judge Fahey decision in Superior Court, where she relied on federal precedent, again, in trial court, and said that she applied the federal rule again. And so again, the federal rule is that attorney's fees don't apply unless A or B. And then the federal rule also requires that the damages multiplier be included. So that's a difference. In Massachusetts, our legislature enacted 212 Section 3 in 2004, but it only partially abrogated the common law rule. So it said, it was silent on the issue of attorney's fees. So there are several canons of judicial interpretation that I can go through that would be relevant here if you're interested, Your Honor. The first one is that the plain language controls. So we shouldn't read an exception into the statute that isn't there. That's related to the Latin for casus omissus, which is a matter not covered by the statute should be treated as intentionally omitted. And there's a Massachusetts decision called Shin v. Weaver, which gets into a lot of the different aspects of statutory interpretation. And they say that when a statute is silent on a subject, as here, and you have a lot of case law before the statute is enacted, that's quite persuasive. That we can assume that the legislature was aware of the common law rule and failed to abrogate it.
What is the case law that existed before the statute was enacted? I mean, we
Sure.
don't have any appellate decisions in Massachusetts.
That's right, you don't. But I have a list here of several, many, but the first one, I went back, the first case is Missouri State v. Life Insurance.
You're talking about federal cases.
Federal cases, and that's right. And I actually wanted to talk a little bit about the darkness that surrounds this issue in Massachusetts and why that is. So
Okay.
212 Section 3A says this is the end of the road for us. If we're not successful here, we can't appeal this issue further. And that explains why we don't have any cases in Massachusetts on this issue, despite the fact that it's an issue that absolutely every case, well, no, not every case, but 90% of cases filed either in the district court or in the superior court are all vulnerable to most tactical motions to dismiss for this issue. And in fact, in the district court, they're even more vulnerable because the SJC has said there is no discretion and the district court must dismiss a case that does not meet the jurisdictional amount. So I think that was an inadvertent, that's an inadvertent problem on this issue, is that we don't have any appellate authority because we're not entitled to appeal it further. So I don't know.
Okay, I'm not sure if that's correct, but I'll just assume that's correct for today. But am I to presume that the legislature was aware of federal common law interpreting the federal diversity statute? That I
would argue that yes, that under these canons of judicial interpretation. Now, a canon is not law, of course, but in the absence of express legislative history, then we can use these canons to help us interpret what we should do in all cases. And Your Honor, I do think I'm correct about Section 3A, although I'm wrong 10 times a day, so maybe this is one of the times that I'm wrong. I do think I'm right about Section 3A, and so for that reason, Your Honor, if the rules permit, then I would like to ask you to issue a written decision and perhaps a published decision so that we can have guidance on this issue. Because, for example, I have to file a case on 93A later next week, and the issue is going to be the same. Where do we have enough damages now to meet the $50,000 threshold, because it's been increased since January of 2020? Do we have the jurisdiction or not? It's a question that everybody faces. I see I have 3 minutes remaining. There is an issue in my case that is not a legal issue, but after our complaint was filed and after we opposed the motion to dismiss, we were made aware of accounting fraud or alleged accounting fraud relative to my client's 401k. So when we go back to if we were to have to go to district court, we would be in a position of alleging greater now than $25,000. And so if Your Honor could also please make a finding about whether if we do find ourselves in district court, does the $25,000 rule apply because our complaint was filed in April of 2019, or does the new rule apply, the new higher $50,000 limit? There is one more point that I wanted to make, and that is about the Wage Act in general. If it turns out that Your Honor finds that attorneys, or that the statute doesn't include attorney's fees, then the result will be that lower income employees, hourly employees, will be litigating in district court before a jury of 6, and higher income wage earners will be litigating in superior court before a jury of 12. So that would create a 2-track system for wage earners, which would be unfair, and it would be contrary to the spirit of the Wage Act, which was designed and which includes the attorney's fees provision, because it does want to create a level playing field for people who cannot afford counsel to have their grievances fully heard.
Well, the carve out for multiple damages would also discriminate against low income earners, wouldn't it?
That's true. That's true.
Wasn't the judge correct that the multiple damages provision and the attorney's fees provision in these kinds of statutes serve the same deterrence function?
Which judge? You were talking about Smith Barry or
Judge Barry Smith? Yes.
I didn't see him make any comments on the public policy, but
I read his finding to be that because the multiple fees provision, the carve out, because the multiple fees provision serves the same deterrence function as an attorney's fees provision, that they should be treated the same. So if there's a carve out for one, there should be a carve out for the other.
I certainly see that he read something into the statute that wasn't there. I don't think his motivation had anything to do with which litigants would be in which courts relative to the amount of money they earn. I think he was just didn't know what to do, there was clearly an ambiguity, and he went against the canons of statutory interpretation that are standard and that are discussed in Sheehan v. Weaver, and did something that we think is fundamentally wrong and very much in contravention with the established precedent. Thank you.
Attorney Rajwani?
Good morning, Your Honor. Good morning,
Morning.
Alexis.
Good morning.
I do not think I'm going to take up all of my time. The points I would like to make, and I think we've narrowed down the issue, is we're really talking about legislative intent. And so under the Wage Act, I agree that there are provisions and deterrence provisions for treble damages and for attorney's fees. I do not think it was the legislative intent of the Massachusetts legislature with regard to General Laws Chapter 12, Section 3, to allow every claim that could potentially have attorney's fees that exceed $25,000 to be brought in Superior Court. There's a distinction for the money damages that have to be alleged for certain claims to be brought in Superior Court versus District Court. Not allowing plaintiff's claim to be brought in Superior Court does not prejudice her rights, in my opinion, at all. She would still be entitled to the protections of the Wage Act in District Court. And as Your Honor knows, in any litigation, if we look at it prospectively, in any litigation I'm involved in, and I've had wage claims in District Court and Superior Court, once you start getting into paper discovery and you start taking even a couple of depositions, you can reasonably exceed the $25,000 threshold. So holding as plaintiff is requesting that Your Honor hold would basically turn every wage claim, I think every 93A claim, where there is a potential of recovery of treble damage, not only treble damages, but attorney's fees. It basically takes all of those cases and allows all of those cases to be brought in Superior Court. Even now with the $50,000 requirement, I do not think that was the legislative intent. I think what we're trying to determine is—
Well, I mean, I think when you determine prospectively what fees are going to be, there has to be some sort of reasonableness requirement grafted onto that. But I mean, you speak of legislative intent. I look at the statute, and the plain language of the statute talks about recovery. And then there's a carve out for multiple damages. And it seems to me if the legislature wanted to carve out fees, it could have easily said so, and it didn't. So how do I glean legislative intent from that?
Well, I think because of the lower court's opinion that we were talking about earlier, the purpose of the attorney's fees provision in certain statutes is the same as that for multiple damages. It's deterrence. And so the fact that the attorney's fees provision isn't in there because some statutes allow for attorney's fees and some do not, I do not think then that Your Honor should read into the fact that where there is an allowance of attorney's fees, that is something that needs to be analyzed in every case in perspective. I think that would become very burdensome to do that. And I think the case law cited related to federal diversity jurisdiction is inapposite. I don't think that really, and I could go through the cases with you in the Walmart case and everything else and why the remand and diversity jurisdiction and aggregation, none of those things really have anything to do with the issue that we're talking about.
No, we're not talking about aggregation.
Right.
But this isn't a class action, right? So
exactly.
So I mean, it's talking about a different statute, but it seems that the reasoning of the federal cases is at least persuasive.
Sure. And I would say that I understand that there is reasonableness that can be, if Your Honor decide to go that way, can be analyzed with regard to that. But I think that's a difficult thing to do at the outset of a case before all of the issues are known.
Well, in this case, do you agree with the judge's conclusion that the fees are almost certainly going to exceed whatever the difference, $8,000 or $9,000.
Do I agree that reasonable fees could exceed that in this case?
Right.
Not necessarily, because I think for the purposes of pleading this case only and answering the case, we're taking as true all of the allegations that were made in this case. And so the plaintiff's damages really are nowhere near the 16,000 that we're admitting to for the purposes of trying to get this case dismissed for lack of subject.
Okay, but the judge took the 16,000 figure to be made in good faith, and then found that the attorney's fees are going to definitely exceed $8,000 some dollars. Do you dispute those findings?
I don't dispute the findings the judge made. And he, of course, was in a position to do that. And certainly that is actually one of my arguments, is that in just about any case where you're coming lower than the threshold amount, counting single damages only, almost every case then can make that same argument that reasonably, to even argue over $5,000, you're going to spend another $20,000 in attorney's fees, which is why I'm coming back to the policy.
Right. So why is that bad policy?
I think it's bad policy, not necessarily. Well, one, I don't think we're here to make policy. I think what we're here is to determine legislative intent.
That's right. So I'm not here to make policy. So I don't know if it's good or bad policy, whether all these cases are heard in Superior Court. So why am I not just bound by the plain words of the statute?
Well, because the plain words of the statute don't say, they don't address this question, Your Honor. They don't say that multiple damages shall not be controlling. But where there is a statute that provides for attorney's fees, that you, Your Honor, should then.
No, right. But it says if recovery is likely to exceed $25,000, then the case is properly in Superior Court. It doesn't say recovery of damages. It says recovery. Then there's one carve out for multiple damages. There's no carve out for attorney's fees. So it seems to me I would be reading an exclusion into the statute that's not there. And how do I do that based on my own beliefs of what's good policy?
So I think recovery, if you're looking at this statute by the plaintiff, I think then is, if you read it in context, I think that recovery really does mean recovery of damages and not attorney's fees. Otherwise, I think it becomes, I think it then obviates, it gets to the point of almost obviating the jurisdictional limits and the distinction between the district court and the distinction between that and the Superior Court money damages limit. Otherwise, I think that if attorney's fees are to be read into all of these cases, I just do not think that was the legislative intent at that time, to open up a greater amount of cases to come to Superior Court, where those cases can be heard in district court, where those cases can be filed in district court. And and since the legislature has already made that decision, I don't see it as prejudicial to have a jury of 6 versus a jury of 12 to then allow any case where attorney's fees could assist in exceeding this $25,000, $50,000 threshold limit. I just do not think that's what the legislative intent was. And I do not think that you would be reading a limitation into the statute, but rather actually interpreting the language and the intent of the statute.
Your argument is that I should interpret recovery to mean recovery of damages.
Yes.
Okay, let me ask you this. So in the district court, from what I understand, there's an inverse rule that requires the district court to dismiss a complaint if recovery is going to be more than what used to be $25,000. So let's say you have a plaintiff who is earning low wages So the damages are not going to exceed $25,000, but the issues are very complicated. Let's say it's a class action of low-income earners. The defendant would not have a right to take that case to the Superior Court when there's a possibility that the attorney's fees award is going to be very, very high.
Yes, if I understand your question correct, yes, that case I think should stay in district court because those damages, my understanding is, can still be awarded by the district court, correct? We're talking about a jurisdictional limit. It doesn't mean that in this case, or let's just take a random case, if somebody were to get a $10,000 award and that was trebled, and then there were $50,000 worth of attorney's fees, that award could be made by a district court judge or jury without violating, I think, the statutory scheme. That's my understanding of how it works, that when you bring the claim, it really has to do with the anticipation of those damages at the time. That does not mean that there aren't going to be Superior Court cases that are properly filed where there's going to be a zero award, where there's going to be less than 25,000, or that there are courts, or there are cases filed in district court that are properly filed where you're going to.
So the defendant wouldn't have the ability to take the case to Superior Court, even if it's on the hook for a very high attorney's fees award. That's what I'm asking.
Right.
Because you're talking about policy, right? I don't know.
Mm-hmm.
There are so many, hypothetical situations that I can't account for, all of them.
Yeah.
And it seems to me, if I read the statute the way you're arguing, then a defendant in that situation would not have the ability to take the case to Superior Court.
I think that's right. I think that if you add attorney's fees where they may be recoverable or even are mandated to be recovered for a prevailing party. So here there could be a recovery of nothing. If we were to prevail, there'd be no attorney's fees.
And there'd be no damages. So, it's everything's perspective, right?
Sure. So no, I think, Your Honor, that's right. That if it's properly in district court and it turns out to be a very complicated case, or you even anticipate that it's going to be a very complicated case that has 6 figures in attorney's fees, I still think my understanding of the statutory scheme is that case stays in district court.
Okay.
Let me see if I have anything else. That's right, Your Honor. So we would just respectfully request that you uphold the lower court's decision and dismiss plaintiff's claims for failure to properly plead the required statutory amount for jurisdiction in Superior Court.
Okay, thank you. Attorney Darcy, you said you wanted to file a brief.
If that would be helpful to Your Honor, because I know I mentioned a number of cases and that I haven't given you citations for. So,
when do you think how much time do you think you'll need?
Well, I'm going on vacation next week, hopefully. So I was thinking on or before August 15th, or I could do it the week before if that's too long for you.
That seems like an awfully long time.
Okay, I can do it. Let's see. How about August 1st?
I was thinking more in the realm of days.
Okay, tomorrow. I can put something.
If you just wanted to give me some citations and file the complaint, that would be helpful to me.
Well, I'm pretty much there, Your Honor. I can submit something to you over the weekend and have it in by Monday.
Okay. How about by close of business on Monday?
Yes, close of business.
And then Attorney Rajwani, if you'd like to respond by close of business on, let's say, July 22nd, Wednesday?
Sure, Your Honor.
Okay. You don't have to. Just if you'd like to, I'll wait until the 22nd.
Sure, that'll give me a couple of days. That should be fine.
Okay.
All right.
All right. Thank you to both counsel. I'll take the case under advisement and it's submitted. And that concludes our session. Enjoy the rest of your day.
Thank you,
Your Honor. Bye, Alexis.
Goodbye.
Okay,